and go. I know, that was dramatic, wasn't it? Um,
Now, given that it's live, I guess the question is, this is being recorded, I assume?
It is being recorded automatically is my understanding.
Okay.
One of the questions that I have is, okay, and you see that there's a private chat feature where if you and I need to
Yes.
chat at the bottom as well?
And then the chat in the audience messages will be there. In my far right is what it looks like on my layout.
I believe so.
And then if I want to post in the regular chat, if there was anything, I mean, I don't know that I would, I'd probably say out loud, but if there was something I wanted to post in the full chat, how would I do that? Oh, wait, maybe it's up here. No, that just elevates the private chat. Oh, well, I'm not going to worry about it. Anything I need to say to the group, I'll say out loud.
Yeah, I am not sure on that either as well.
But they all have the opportunity to go into the main chat.
I believe so, correct.
Okay, cool. And now that it's open, they'll start drifting in as they come from their previous workshops?
I believe so. That is one thing that I am not sure exactly how I don't know how to see which participants we have in it.
Yeah, I looked last night. It looked like there were 10 signed up if I read it right, but
Mhm.
at the same time, I wasn't convinced I was because I knew there were a lot more people signed up as a whole, and so that's why I just wasn't sure who was, interested in the topic, who would be in coming in, that kind of thing. So, because I know there are also a lot of good topics being offered today. So,
True. I believe that there are 2 other sessions, during this hour as well. So I'm asking for a confirmation that we are live and it is recording. But I'm okay. Yes. So we're good to go. Hi everyone, welcome. We are waiting for folks to drift over from their last panel, so we'll just give it 1 or 2 minutes before we get started. Okay, and so it looks like we've got about 18 folks who have joined us so far. I know others are going to start drifting in, but I'm going to go ahead and start our introductions for the day. So good morning, everyone. My name is Natalie Teague. I'm a member of the Board of Directors for the Foster Family Alliance of North Carolina, and I'm thrilled to be able to host this session today with Evan Friedel, who is here from the Family and Children's Resource Center of the University of North Carolina at Chapel Hill School of Social Work. I'm going to let him introduce himself a little bit, and you can read all about him with his bio that is posted on the Socio platform. But I did want to offer a couple of tidbits. So we will have a live chat going through this. So one of his skills that he has shared with us is that he has an ability to offer a dad joke at any time. So Evan, I'm pretty sure you're going to have to be put on the spot for that one at some point in this. But he has 27 years in the field with child protective services, practice and reform, grief counseling support, secondary trauma, focus on integration of data with practice, BA in psychology from Washington University in St. Louis, and MSW from the same school as well in 1984. And so, Evan, I'm going to go ahead and turn this over to you. Thank you so much for taking the time to be with us today, for presenting everything. Folks, I'll be monitoring the chat, and we will be taking questions at the end unless it's just an absolute burning question that we have to handle. So, Evan, welcome. Thank you so much for your time this morning.
Well, great. Thank you, Natalie. And I appreciate y'all inviting me. I am very excited to be here. It is my pleasure and privilege to have an opportunity to present to y'all this morning. Just a quick couple of things about me. Natalie talked a little bit about it. I do absolutely not take myself too seriously. I do take the work we do incredibly seriously. This work is incredibly important. The work that the child welfare professionals do, the work that as resource foster parents and families do is absolutely essential, and it is my passion to be able to help support that. uh, as Natalie said, I work currently with the UNC School of Social Work Family Children's Resource Program. I am a training specialist with that program. Prior to that, I worked with the North Carolina Division of Social Services for the last 15 years. I spent the last 3 of those years working as their Title 4E coordinator. Some of you know what 4E is, some of you don't. If you don't rack your brains about that. It is not worth the gear grinding, I promise you. Um, I also worked as a children's program representative during that period, working as a liaison between the division and the counties, helping them to improve their practice to children and families. Prior to that, I worked with Forsyth County as a program manager in children's services, as well as a supervisor before that in foster care. And then before that, I had the opportunity and privilege to work with the North Carolina Eye Bank doing eye and cornea donation for transplant and research. I had the opportunity to work with Hospice of Winston-Salem as a social worker. And before that, I worked with North Carolina Baptist Hospital as a cardiology social worker and in their heart transplant program. So I either have had a very varied career in social work or I can't hold down a job. I will leave that up to you to decide. However, the first dad joke of the day is, what is a pirate's favorite letter? A lot of folks might think it's R. And it'd be R they like, but it'd be the C they love. So, one of the things I want to encourage you, and Gail has put this down in the chat already. How many of you have questions about permanency? I am betting a majority of you do. Um, and hopefully you will put those into the chat throughout the day. I can guarantee you in the time we have together, there are going to be no silly questions. There may be silly presenters, but there are no silly questions. Anything you're wondering, I guarantee you somebody else sitting next to you virtually is wondering something similar or in a similar vein. So please don't hesitate to ask those questions. We will do our best to answer them all and help you guys get as much information as we can in the time we have together. So with that being said, I'm going to jump in and start our conversation about knowing your options, understanding the difference between adoption, guardianship, and custody. The first thing that's important to understand is what we're talking about when we talk about permanence. And some of this I realize may be a review for you, for some of you, but for others of you, it may not. So we want to make sure before we talk about where we're going that we know where we've been. And understanding what permanence is a big part of that. Um, so, permanence occurs is when the legal responsibility of the child or youth in foster care is given to a caregiver or caregivers who agree to provide care to the child forever. I mean, it's as simple as that. It's what it sounds like. It is a permanent outcome for the child. However, it's a legal process and ultimately has to be started and finished by a court of competent jurisdiction. A court and a judge has the final say. And that's important to recognize. A lot of times, departments of social services, guardians ad litem, parents' attorneys are assumed to have sometimes more power than they do in the process. And that includes parents, foster parents, relative kinship caregivers, fictive care, a fictive kin, uh, all think that sometimes they have, unfortunately, more power in the process than they do. It's not to say that they don't have a voice in the process. They absolutely do and should have a voice, and that voice should be used as much as possible. However, ultimately, All of those parties make recommendations, and it is up to the court to make the final decision about what permanence is going to be applied to the child or children in question. So we like to make sure that people understand that as we go forward so we can be aware of that particular perspective. So keeping that in mind, we're going to talk about the pathways to permanence. How do we get there? So we know what permanence is. It's a legal resolution to the fact that a child has been brought into the care of the Department of Social Services, and that method of entry of care can be through any number of ways. It can be through filing a petition from the court. DSS can file a petition asking for custody. It can be through a relinquishment. A parent can relinquish their rights. A parent can do a VPA, a voluntary placement agreement. Those are rarer these days, but they do still occur in some counties. A court can actually give custody to DSS through other avenues that are not DSS court. It can be through truancy court. The court can give custody to DSS because sometimes apparently DSSs are magic and they can accomplish things that other areas cannot. At least it feels some days like that's what the court's view is. So they grant custody to DSS in those scenarios. But judges can also grant custody to a DSS in a divorce hearing, a custody hearing. They can do that while they're trying to determine what's best for the child. It's not common, but it does happen. So when we talk about pathways to permanence, we need to understand what our options are. So what's in front of us? The first one is reunification, then adoption, guardianship, and legal custody. And these are listed in the order of most permanent. And what we mean by that is the permanency that is least able to be revoked or changed. Okay, so we're going to talk about all of these in a little bit of detail as we go through this morning. And again, I encourage you, even though we'll be holding questions till the end, as questions pop up, please make sure you're putting them in the chat box. Natalie's going to be monitoring those and helping to keep track. And so we want to make sure that we're giving you guys those opportunities uh, as we go through this morning. So the first thing we're going to talk about is reunification. Okay. Reunification is going to be the primary plan and goal for most children entering foster care in North Carolina. Now, many of you are aware, and if you're not, statute requires that the children have a primary goal and a concurrent goal when they enter foster care. If they enter through a petition being granted where DSS is given custody or DSS is granted custody through one of the other means I mentioned earlier, the DSS has to present a primary plan and goal, and those goals are discussed during the meetings you have with the DSS, the family will have, and as resource parents, you should be invited to those meetings. But the plans are going to be developed, and reunification is going to be in probably well over 90 some odd percent of those cases going to be your primary goal. And that makes sense because the reality is, when we first talk about it, is if a child can be kept safe and protected and their needs met, the best place for a child to be is with their family. Research shows this. However, there aren't always those scenarios. And when we talk about when reunification isn't an option, we're going to talk about those other opportunities in a moment. But reunification means that the child's final permanence is with either parent or the person that they were legally removed from. And that's different than the placement that they may have been physically removed from at the time custody was granted. We know sometimes children may be in the legal custody of a parent, but residing with a relative, a friend, whomever, and they are physically removed from that home, but they are legally removed from the parent or the person with custody. So when we talk about reunification in those scenarios, we're not talking about reunifying necessarily with the environment the child was removed from. We're talking about reunification with the person whose custody they were legally removed from. And what's critical about that is the parent or the original caregiver must demonstrate that they can ensure the child's safety and well being at that point. Whatever issues brought the child into care have to be addressed satisfactorily to the perspective of the court, and all the parties will have an opinion about that. Those opinions are the opportunities are to present those to court through the various attorneys and the trial process, court process, and ultimately the court makes the decision if a child is reunified that those caregivers have met those needs as identified throughout the court process. That is the hopeful process in, like I said, in many cases. It is not always achievable for any number of reasons. If reunification is not the best option or an available option for the child or children in question, then we would turn to the next most permanent uh, goal, which is going to be adoption. So when we talk about adoption, some things to understand about adoption. Adoption is the most stable form of permanence who can't be returned to their parents, okay, or the person who they were legally removed from. The court is creating a new legal relationship between the adoptive parent and the child. This is important to understand because, regardless of what the relationship was between that child and the adoptive parent prior, and what I mean by whatever the relationship was, if this is a family member, because we are lucky enough to have in many scenarios family members who are willing and able to step up in addition to the wonderful people who are willing to step in as licensed foster parents from outside the family. But if they're family members, they may be Grandma Jane, Uncle Joe, whatever. But the court is creating a new legal relationship between that adoptive parent and the child. Legally, that adoptive parent is now their parent, and that adoptive parent has the same rights and responsibilities as a birth parent would have. So I want to make sure y'all understand that. It doesn't mean that the adoptive family, is forced to say, okay, I went from Grandma Joe to now mom. That's a choice that the family can make. And hopefully, if you're a child welfare professional, you're working with your adoptive families, especially if it's a relative caregiver that's considering adoption, to really have good conversations about that, especially recognizing that in a number of those scenarios, the biological parent may not be completely out of the picture. There are a number of times that they are, but there are a number of times that they're not. And so helping the family consider what the options they may be facing are will help them prepare the child for what's coming next and what will come over time. Because let's face it, children are inquisitive creatures. Anyone who has a child of their own, I have two, I'm blessed. I have allowed them both to make it in through teenagehood. I have one who's in college right now, and the other 17-year-old going on 30. And Lord, does she have a championship eye roll? I will tell you that. But they will want to know. And so the more that you can be planful in the adoption process about discussing these relationships and how you want them to play out, the easier that will be. But the adoptive parents, in the eyes of the law, regardless of what their biological relationship is, they're going to be seen as their parent, and they're going to have all the rights and responsibilities of birth parents. And more importantly, these adoptive rights don't end when the child reaches a certain age. So this is not something that expires. When a judge bangs a gavel, signs a adoption decree, that adoption is just as, and that relationship between that adoptive parent is the same as it would be as if you had given birth to that child. It only ends if it gets legally separated at some point down the road, just like a birth parent relationship would be. So, some requirements for adoption. So, let's talk about how we get there. The child has to be legally free, meaning the parental rights to the child or for the child are ended either voluntarily or involuntarily. Um, Voluntary right end to rights by the parent is called a relinquishment. Parent has the right to relinquish their parental rights. They can do what's called a directed relinquishment, where they may relinquish to a specific person, indicating who they want to be the caregiver for that child. Or they may do a more blanket relinquishment, where they're just relinquishing the rights of the child. DSS is taking those rights temporarily via the court, and then ultimately, with the court involvement, permanence will be granted to that child. An involuntary end to parental rights is conducted by the court via a termination of parental rights, or TPR. You'll hear me use the term TPR probably a bit this morning, so we like to make sure y'all understand what initials and acronyms we're throwing out there. The other thing that's important to know is that if it is a child over the age of 12, they also have to consent, which means they need to be involved in the process. As you can imagine, children over the age of 12 may have certain feelings about this process. They may have feelings about what has gone on for them that's led them to this point, what issues they may have experienced. And so it is critical, as child welfare professionals and as resource parents, that we are helping support the children throughout their journey. And as much as possible, try not to take it personally if on initial pass and initial approach, the child doesn't want to be adopted. Remember, if they're old enough to understand that they are open for adoption, that their situation is, for lack of a better term, they are available for adoption. I don't love that term, but it works. Um, they also are old enough to potentially understand that they've either been rejected by their parent, or they have been placed in a situation where someone has said that that relationship is no longer viable. And it's important to allow them time and space to grieve that process. Okay. Some other things to understand about that is relinquishment does have a certain time frame for revocation. So if a parent signs a relinquishment, a DSS is required to wait that period before the revocation i- is allowed to be passed. And a TPR does have appeal rights for a parent. So even if a court grants a TPR order, the parent does have the right of appeal. And if they exercise that right, then the Court of Appeals has to weigh in and make a determination on the validity of that appeal and whether or not the appeal stands. So there can be delays in moving into adoption, even if the court grants that TPR. Once the relinquishment window closes, the revocation window, that is permanent. So oftentimes, relinquishment is a quicker way to get to legal freedom for a child. Now, some potential benefits for a child via adoption. First of all, adoption assistance. Okay. Adoption assistance, we're going to talk about in a minute, but it consists of both financial and potential medical support to the adoptive parents for the care of the child. There are post-adoption services that are available through the local Department of Social Services as well as other contracts. There can be potentially post-secondary school support via the NC Reach or ETV program for the child. There are non-recurring adoption expense reimbursements that can be made available if the adoptive family has incurred certain expenses that are considered appropriate in the adoptive process. There may be a one-time federal tax credit for the adoptive families. There can also be options where medical and therapeutic vendor payments, if certain situations arise where there are certain needs that are identified and appropriate for the child based on identified medical needs or therapeutic needs, then if those have been approved, then there can be reimbursement for some of those costs. That has to be worked out with your DSS worker. But it is potentially available. And there's also the LINKS program. That's a federal program that's administered by each county. And it is a service program and support to children who have been in foster care for teenagers. So it's an excellent resource to help support children, teenagers, and young adults as they move through their current and post foster care experience. So when we talk about adoption assistance, and I know I'm moving a little bit quickly. Unfortunately, I could probably talk about all this all day. So I encourage you to make sure you're asking your questions as much as you can, and we'll do our best to circle back. But adoption assistance, a child has to meet one of several medical or social requirements in order to be eligible. These are set by the federal government. This is not set by the state. This is the same in any state in the union. The federal government says you have to meet some of these particular guidelines. Some of those guidelines, just to go over them real quick, is the child has to meet one of the following categories: has to be either 6 years or older, has to be 2 years or older, and a member of a minority race or ethnic group, has to be considered a member of a sibling group of 3 or more children placed in the same adoptive home. The child has to be member of a sibling group of 2 children to be placed in the same adoptive home where one or more of the siblings meet at least one of the other criteria. The child has a medically diagnosed disability which substantially limits one or more major life activities that requires professional treatment, assistance in self-care, or the purchase of special equipment. They could be diagnosed by a qualified professional to have a psychiatric condition which impairs the child's mental, intellectual, or social functioning, and the child requires professional services for these. Um, the child is diagnosed by a qualified professional to have a behavioral or emotional disorder characterized by inappropriate behavior, which deviates significantly from behavior appropriate to the child's age or significantly interferes with the child's intellectual, social, or personal functioning. The child is diagnosed to be intellectually disabled by a qualified professional, or the child is at risk for a diagnosis described above, but if a child is only identified at risk, they wouldn't be able to qualify for financial payments at that point. They would be eligible for Medicaid, but would be eligible for medical payments in the future if a future diagnosis related to the condition identified in the adoption assistance agreement and in the adoption pre-adoptive checklist, the process that your foster care worker is going to go through with you prior to adoption. If that condition exists, that risk factor exists, and a later diagnosis comes up, then it can be revisited. Okay? There has to be a determination that a reasonable but unsuccessful effort has been made to place the child with adoptive parents without providing adoption assistance or Medicaid. The reality is that adoption assistance, to be perfectly candid, shouldn't be given out like candy. It shouldn't be given necessarily to every family that adopts. I realize that's not always a popular position, but it's the intent of the federal government. It was designed to help support families who are taking on a commitment to children who might be considered otherwise difficult to place or difficult to achieve permanence. Now, there are lots of ways to address this requirement, and most DSSs do an excellent job of helping to make sure that's met one way or the other. But it is a question that every DSS should be asking prior to an adoption and considering adoption assistance. Um, an important one here, and this one gets people in trouble at times. The agreement has to be signed and completed prior to the adoption. So I say this to folks on both sides of the line. If you're a resource parent, make sure you're asking about prior to the adoption. Have we done all of the adoption assistance work? Um, and have we signed our paperwork? Has the director signed it? You want to advocate for yourself to make sure all of those documents are signed. And if you're a child welfare professional, you absolutely want to make sure that those documents have been signed and completed correctly by the agency prior to the decree being signed. I cannot state that as enough. That is the number one cause for error and for adoption assistance agreements to be potentially held up or possibly suspended. And oftentimes, what will happen in those scenarios is there may be a decision that the adoption agreement may be considered valid in that the adoptive parent may still continue to receive the payments, but the county will no longer be reimbursed for those payments, which means it's all county money. If this is done correctly and accurately, there's major federal share in that adoption assistance payment. So we want to make sure we're getting it right. And the financial amount that is offered when a family qualifies for adoption assistance is specifically tied to the board rate. Okay, so when the board rates change, and those of you who are child welfare professionals or licensed resource parents know that those board rates are posted every year. We just recently, I believe, had an increase in that. Before that, it had been a while since we'd had an increase. Um, but they are tied to those. So based on certain ages, there is a rate paid, and that's what the adoption assistance rate would be. And if the child moves up in age and moves to a new category, then they would qualify for the next level of care, next level of payment based on their age. So post-adoption services. These are designed to offer families a network of support, links to resources, parenting programs, counseling, and crisis intervention. They're primarily provided by the county the family resides in, regardless of where the adoption occurred. This is important to recognize. It's always good to potentially reach back out to your home county. They know you best. But if you move, the county you move to would be asked to provide those services for you. So if you have issues, you can always reach out to your home county, your original county, county of adoption, and say, I'm moving to X county. Can you give me a contact? Or if it's been years, let's say you adopted the child at a younger age, the child gets older, and is infected with that disease we affectionately call teenageitis, well, guess what? You could reach out to your local DSS and say, I've adopted this child through child welfare in the past. I'd like to talk about some post adoption support services, and they will hopefully be able to get you connected. DSS also contracts with providers to provide supplemental services or to supplement the services by the local DSS agencies. And I know it looks like that this link that I've put up here in the PowerPoint is cut off. It's not. And it took me a long time to figure that out. The and at the end, I keep thinking there should be more to it than that, but there isn't. If you cut and paste that into a browser, you're going to be able to uh, get to the link through DHHS that will help you find connection to those services. And it talks more about them in detail. But it caught me off guard the first couple of times I was playing with it because I'm going, I know I've cut this off, but no, that's the link. So we wanted to make sure it's here in the PowerPoint so you have it as a resource if you might need it. Now, some other resources that are available to children as they get older are NC Reach and ETV. NC Reach can pay some costs after other aid, so that you have to apply for traditional financial aid. But if a child is going to a North Carolina public college or university and they were adopted after the age of 12, they may be eligible for the NC Reach program. And there are a number of different requirements you have to go through, and I'm not going to go through all of them here. We've got the link here for you if you want to pursue that. I encourage you to. College can be an important step for young adults as they go forward, and NC Reach can help adoptive parents and children achieve that goal. However, there's also, it's not to say that college is always the best move for everyone, nor should it automatically be. So if people are feeling like there are vocational training programs that they are more interested in, or areas that, as opposed to the traditional 4-year schooling that they want to pursue, the ETV, the Educational Training Voucher Program, is available. Now, the requirements are a little bit different. You have to have been adopted after the age of 16. But there is federal funding if they meet the qualifications. And again, that link is here. So you can pursue that if you are interested and learn a little bit more about that program. But these are two programs that children who are, if they are adopted after a certain age, can be eligible for, and it can help defer costs. We all know how much college and other training can cost. Boy, do I know that as I'm looking at sending my second child to school in the fall. By all means, you want to make sure you're taking advantage of everything that you're entitled to. The way I always look at it and present it is, if you put in the hard work, we want to make sure that you're getting the benefits back. The non-recurring adoption expense repayment I mentioned earlier, it does reimburse certain expenses incurred by the adoptive family. It is a one-time expense. It is up to a $2,000 maximum, and it's facilitated by the local DSS. A lot of times that would be things like if you have an attorney working with you or representing you for whatever reason in the adoption, if there were certain studies that needed to be done or whatever that were handled out of pocket, they can be reimbursed by the local DSS. You would want to reach out to your local DSS and to the caseworker to discuss those expenses, but they can be available. So we want to make sure that folks know that that is a potential option if adoption is the route that you're going. The adoptive tax credit for parents who adopt children from foster care. This is important, from foster care, not just necessarily a direct adoption. They can be eligible for a one-time credit. We encourage you to consult your tax advisor. I am not a tax advisor, nor do I play one on television. But this link through NACAC can be one that we have utilized in the past to help adoptive and resource families get more information about the tax credit. But this is always good to know about, especially as we are approaching tax time. Medical and therapeutic vendor payments. The payments made for services provided to children with special needs. The special needs have to have existed prior to the adoption or be related to a pre-existing condition. So if it's not a condition that existed prior, there has to have been a link back to it, this new diagnosis, to something that existed prior. Okay. The local DSS determines the eligibility, and then it has to be approved. So this is going to not be an automatic, okay? And it's not going to be, in the past, many, many years ago, again, this was something that was, I hate to say it, taken advantage of at times by folks. Just because a child has some educational needs doesn't mean that they automatically can qualify for a computer every year, or that they can qualify for summer camp. It doesn't mean that they can't, but it means that we have to work very hard to make sure we're providing the connections to those needs and the benefits that the resources that we're providing. So the reason I say that is I don't want resource parents to automatically be surprised if a county challenges a request for a vendor payment. It doesn't mean it's going to be a blanket no, but it means that both the federal and state government have encouraged very strongly that we look at, why are we asking for what we're asking, and what is the benefit to this child? What is the connection to the need that existed before? Because if you think about this, going to what I said earlier, the adoption assistance program and these other supportive services are designed for children that might otherwise have challenges uh, to be adopted, or might have issues related to the reason they were brought into care that may affect them down the line. So these services are designed to supplement that. So that's where this connection comes in, and why it is scrutinized so heavily. And then we have links to statewide program for children who are in foster care after the age of 13. They're eligible for continued support and service post permanence. Every county has a links program of some form or fashion. Different counties' programs are developed in different ways and to different levels, but they are excellent resources. They are great supports. The links groups that many counties will run help peers, young adults, process and be together and learn they're not alone. And that can be hugely helpful for children in times of crisis and challenge. And it's provided by the local DSS. So I'm going to pause here, take a quick breath, give you guys a second to catch your breath as I speed through all this. And again, I apologize for the speed at which I'm moving through, but I want to make sure I cover as much as the information as I can and make sure we have some time for questions. Uh, but we're going to move into guardianship. Natalie, did I hear you come on the mic?
I did. Yeah, Evan, we've had some questions come up in the chat, so I figured before we moved on to that, maybe we could address these about adoption. Is that okay?
Absolutely.
Okay, so we had a question about if you have adopted a sibling group of if you have adopted a sibling group of two without adoption assistance, and then a third child comes into care, and you agreed to adopt the third child too, would you receive the payments for all three children, or just the newest child, or none of them?
It's a great question, and the answer is it depends. I hate to give that kind of wishy-washy answer, but unfortunately, it does depend on a number of different variables. What I would encourage you to do is ask your DSS worker to work through the specifics of the situation with you. If the DSS worker has questions, because this is unique, it doesn't happen every day. And in some ways, thankfully, we don't have multiple children at separate times in the same family having to come into care. But if the DSS worker has some questions about that, the current Title IV coordinator, Beth Riley, is an excellent resource for them at the state. So they can reach out for focus there and help there. Beth's initial experience prior to coming to the Title IV role was also adoption assistance manager. So she is an expert in that arena. So the local counties know her. I have no doubt of that. And they can and should absolutely reach out for assistance that way. So again, I don't want to not answer that question, but there are just so many different ways it could go that I don't want to give an answer that could send them one way and then find out that their specific case issue would go another. And there are just so many variables we could spend all day talking about possibilities. So.
Of course, of course. Thank you for that. So another question is someone's asking, so that I'm clear, after adopting, it's possible that you get no adoptions assistance.
Absolutely. That is a great clarification. Just adopting by itself does not automatically qualify you for adoption assistance. It absolutely can, but it's not a requirement. It's not an if A, then B. Just because you've adopted a child who is in the custody of DSS doesn't mean that that child is automatically going to qualify. Now, it does mean that you likely have met one of the significant hurdles, but there are a number of children who come into custody via DSS who are adopted that may not qualify for adoption assistance. One of the easiest lines I can draw there is our youngest children, okay, infants. While there may be some scenarios that infants do qualify, and thinking substance exposed infants, things like that, that may get them there. A lot of times, infants, because they are relatively easy to adopt, I mean, many parents, families want young children, so they aren't as hard to adopt. And going back to the purpose of adoption assistance, it was designed for these more challenging to adopt children. A lot of times the infants, and if you remember back to the guideline about over the age of 6 or over the age of 2. So if they're under the age of 2, more than likely they're not going to immediately qualify. They may qualify further down the road based on the potential category. They may have one of these potential issues that later on, unfortunately, develops into a diagnosis. But absolutely, just because they're adopted, you might not get adoption assistance. But Medicaid, and I see that in the Gail took that on. Medicaid is available in almost every scenario. There could be a few that it might not, but the financial payment is definitively dependent on these other variables.
Mhm. Thank you for that. There are a couple of questions that kind of touch on guardianship. So we may go ahead with that. But I do want to back up to one of our first questions at the beginning of the hour, which is where do the youth have power and voice around permanency? How are we fighting to make sure that youth have power, voice, and choice in their decision in their permanency? And then how committed are we to change the way we do business as usual with permanency of youth? And so that might be something you want to table until we get further on, but I wanted to go ahead and give you that option now too.
I think we can touch on it now briefly, and unfortunately, it's not a brief topic. It is a huge advocacy topic, and again, could spend all day, all weekend on that, and never get close to coming to fruition. But the DSSs at the local level with the CFTs, the child and family team meetings, the permanency planning team meetings that they're having, when children are of a certain age, essentially that teenage age, 12 and above, their opinions can and should be being sought out. Now, it doesn't mean that they always will attend those meetings. There are a number of reasons why they may not be able to. Obviously, if those meetings are taking place during school and whatnot, we have to have priorities. But the social worker can and should be soliciting those opinions. If the child, young adult, as they may be, has a desire to be a part of the process, they absolutely should be granted that opportunity. And this is where we come at it from multiple standpoints, and hopefully we're all keeping the welfare of the child in mind. And what I mean by that is you have different people representing different interests. Okay, the parent's attorney is representing the parent. DSS is representing DSS's interest, which is theoretically the best interest of the child, but also governed by the laws, statutes, and policies that go as a whole. And then you have the guardian ad litem, who is truly there for the interest of the child and hopefully representing that child's interest. The guardian ad litem is going to help be in some ways, the best advocate in the court setting. But I do know on behalf of the division, who I don't officially speak for any longer, obviously, I'm not as no longer an employee, but I know that one of the focuses of the division is to try and help counties continue to develop that voice for the young adults. And that's why I mentioned the Links program in permanence, because remember that Links is there for children regardless of what their permanency outcome is going to be. So it's a support and an opportunity for them to have a voice. Their social worker should hopefully be working with them on a regular basis to hear that voice through every level of child welfare, whether it's in the assessment stages prior to custody, all the way up through whatever the permanence is. And then we have some phenomenal agencies here in North Carolina, primarily among them Say So, that's helping to get the voice of these children, young adults out there. Not to mention all of the other brilliant agencies that are there helping to support resource parents who are going to help their voices be heard as well. So the intent is there. The federal government is holding states accountable for this through the CFSR process, which is the process by which they evaluate states and territories on the outcomes they're achieving. And again, I'm sort of taking us down that rabbit hole, but it's a good rabbit hole to be down. There is that intent. That being said, we know sometimes where the road of good intentions leads. And that's why it's important in workshops like this, in trainings like this, where people's voice come out and people advocate in every way possible to ask the question, is the child being heard? Now, the other side of that, just to say, is just because the child is heard doesn't mean that what's being heard is going to be acceded to. And the same thing goes for resource parents or even for DSS. And that's why I said in the beginning, courts make that final decision. Just because the someone has an opinion, whether it's the guardian ad litem, the parent's attorney, DSS, the child, whomever, yes, weight should be granted there, but ultimately all those have to be balanced. But I can guarantee you, if we don't ask the question, what does the child want? We're never going to have the opportunity to make sure that that child's wishes are engaged in the process.
Thank you. There's one other question that may kind of loop back around to guardianship, so I'll ask that one, and then looks like we've got about 12 minutes at that point. So
Sure.
guardianship and kinship in 10 minutes, right? But so can the youth under kinship guardianship have a say in changing to adoption, say at 18? And with that, I'm going to let you take it away.
Okay, great. And that is a great opportunity. We're going to talk about guardianship, and then we'll hopefully be able to touch back on that last question. So guardianship, and again, I apologize for the speed at which I'm going to have to take us through this, but guardianship is the second most stable permanent form of permanence following adoption. It is most appropriate when reunification isn't possible and adoption isn't a good fit. Now, that doesn't mean that guardianship should be the default. My view, and it is just Evan's view, but I believe that it is the most appropriate view, and the division has tried to make this a goal whenever possible, is that we need to be asking the question, why isn't adoption a good fit? There can be a number of reasons why that adoption might not be the best answer. One of the benefits of guardianship is that the child doesn't have to be legally free, which means you don't have to go through TPR or relinquishment. There can be times that a parent is not going to be able to have their parental rights terminated. A court may determine that the situation, while it is not good, doesn't rise to the level of terminating those rights. It may be that a family member doesn't want to pursue. They want to, in relative care situations, they may absolutely want to provide a permanent home, but they don't want to terminate that parental right of their family member. So it's critical in my mind that we ask the question, why not adoption? And there may be plenty of good answers, but that's a question we hopefully are asking as caregivers, as child welfare professionals, and as the court. All of these avenues are looking at these and saying, okay, if not adoption, why? But there are some opportunities. If under certain circumstances the child can qualify for guardianship assistance, kin gap, and one of the downsides is guardianship can expire and be more easily terminated by the courts. Remember, I told you adoption has to be terminated the same way birth parents' rights are. Guardianship is a little bit more easy to terminate. It's not simple, but it is easier. Some of the differences with adoption, as I mentioned, it doesn't require the child to be legally free. The court can grant guardianship at any time in the process. This can be a risk at times, especially in COVID world where courts have been backed up. This could be a challenge for courts where they see this as a possible out. Because remember, like I said, the court's the final arbiter on permanence. So hopefully they're not doing it based on time and caseload, but we know reality sometimes interferes, and we want to make sure, and we're certainly trying to encourage at all levels we can, that again, we ask that question, why not adoption? Why guardianship? The legal rights and responsibilities are similar, but slightly different. uh, you get to make decisions about the child's education, discipline, health, and mental health treatments. You can represent the child in court if needed and give written consent until the child turns to the age of 18. You can arrange out of home placement for the child if needed, including therapeutic foster care. So, if you are the guardian of a child and the child requires mental health treatment, which could involve therapeutic foster care, just like a birth parent, you can arrange that as a guardian. You could also grant youth permission to marry or join the armed forces, just like if you were a birth parent or an adoptive parent. However, one major difference is there is no name change involved. Okay, unlike adoption, where you can change the name of the child, In guardianship, there is not. The legal authority ends when the child turns 18 or if they're emancipated by the court. Emancipation is rare, but it can happen. Um, and this gets back to that other question that was asked. Can privately pursue adoption if the circumstances change? There are opportunities by which a guardian can pursue a private TPR and or privately pursue adoption. And so that is still an avenue that can be open if the guardian and the child uh, are interested, and or if the circumstances that seem to make adoption not feel like the best choice arise. There is the possibility, I'm not going to say the guarantee, but the possibility that some of the costs, if the family pursues adoption, could be covered under the non-recurring costs of adoption that I mentioned earlier. You would want to reach out to your local DSS if you're going down this road to make sure what, if any, of those costs could be reimbursed. Guardianship assistance. This is one of the biggest changes that's happened in the last several years as it relates to guardianship. It provides financial support similar to adoption assistance and Medicaid for children who qualify. Medicaid coverage has to be discussed with the local DSS to determine eligibility. It's not automatic. And it does end at 18 unless the child became eligible at age 16 or 17 and meets certain requirements. And some of those requirements would be for it to extend beyond the age of 18 is completing a secondary education program or leading to an equivalent credential. So that's college. Enrolled in an institution where post-secondary or vocational education, participating in an activity or program designed to promote or remove barriers to employment, employed at least 80 hours a month, or incapable of doing any of these activities due to a medical condition which is supported by regularly updated information. Okay, so there is the possibility of extending beyond the age of 18, but you would work with your DSS worker about that. So, in the limited time we have left, I want to make sure you understand what the requirements are. These are critical. Okay, these are not negotiable. The court must, and you'll see it's in bold there, must determine that reunification and adoption are not appropriate plans for the child. This must be laid out in a court order. The court must say those words. We have seen gap payments denied because on review and audit because the court did not make those determinations. So it gets back to the idea of asking the question, why guardianship, not adoption? So the court must make a determination. Now, it doesn't have to get into detail why, but it must make a finding at a bare minimum that reunification and adoption are no longer appropriate plans for this child. The home in question has to be licensed by DSS, and the child must have been placed there for a minimum of 6 consecutive months, not just 6 months at any point, 6 consecutive months prior to the granting of guardianship. Doesn't mean that a family caregiver can't get kin gap payments, but they must become licensed and the child must be in the home 6 months, excuse me, post since being granted, and those 6 months must be consecutive prior to the granting of guardianship. The child has to be at least 14 years of age. A child younger than 14 is not currently eligible for guardianship assistance unless they are a sibling of a child who is 14 plus being placed in the same guardianship arrangement. And the guardianship assistance agreement must be completed and signed by the guardians and the DSS agency prior to guardianship being granted. This is the same as the adoption assistance agreement. Must be signed and completed prior to the guardianship being granted. I'm saying that again with emphasis because we've seen these agreements fall apart because they weren't signed and completed prior. Some other things to know about guardianship. You can be eligible for the educational training voucher similar to adoption if they enter guardianship after the age of 16. There are not formal post guardianship services, unlike adoption, but the court could order the local DSS to be involved with the case and report back to the court. There is no formal tax credit for guardianship. You would want to discuss your situation with your local tax professional as to how the guardianship may or may not affect your tax situation. There are no vendor payments. This is unlike adoption assistance. This is one of the reasons why guardianship is not potentially as beneficial as adoption. And access is, however, available to the child, just similar to the LINKS program. The last one I'm going to touch on, and I'm going to do this in basically 1 minute so we can at least have 1 minute left for questions, is custody. Legal custody is the least permanent of all of our options. It can be granted by the court at any time. It can be dissolved by any court of competent jurisdiction. So if custody is granted, any other court that has the ability to give custody as a disposition can address it and dissolve that custody and grant custody to somebody else. There are no financial benefits attached whatsoever. However, someone who has custody may apply for other services at the local DSS, like food stamps or whatnot, and it'll be dependent on the qualifications of that program. It is, again, the least permanent of all the options and the least comfortable for the caregiver and the child, in my opinion, because of that lack of long-term permanence. So I have raced through these, and I apologize for the speed at which I needed to do that. However, I want to make sure we have at least a minute or two to try and circle back to what questions may have come up. So Natalie, I don't know if there's anything that came up that you think can be addressed quickly.
So let's see. So Evan, I do have a question. There's kind of a case specific question about filing for assistance where a couple had adopted a biracial child at birth in South Carolina. That may be different. I don't know if you want to address that. Did you see piece of
It
that one?
It can be different. What I would encourage you to do is, I would first of all probably try and reach out at first to the South Carolina agency and discuss that and see what the options are through them. If there isn't a option that way or they don't respond, then you could reach out to the local DSS and ask if they can get you in contact, either if they have information or get you in contact with Beth Riley, the 4E coordinator, who also is over adoption assistance now, and she may be able to help give some guidance. But I would always turn back to the agency that facilitated the adoption when we have questions like that, because they're going to be the ones in control of how the adoption assistance was necessarily applied for or not applied for under those circumstances.
Fantastic. And then one other question about if and it's I'm not entirely clear, but when or how could we get the TRIP program back? That it was such a great program that there was more funding for driving expenses. Could you address that just briefly?
I actually cannot, unfortunately. That is not a program that I am as familiar with. So rather than give bad information, I would rather refer you back to the local DSS. And again, if there are questions that the local DSS can't answer, then their state folks, either via the adoption program, the permanency section, or Beth would be able to be the best resource there. And again, I apologize, but I'm fully of the belief better to give no information than bad information.
Certainly. Well, any closing thoughts? Where it looks like that we are at the end of our hour.
We are, and again, I appreciate all of the information. I apologize for those who I haven't been able to answer, and again, that I've had to speed through this. This, as Gail said, we could spend all day on this before we got started, and I think still not get to everything. I hope this is a good start. I appreciate all of you at whatever level that you're doing here, because if you are a child welfare professional, if you are a community partner, if you are a resource parent, you are doing phenomenal work to help bring some level of stability and normalcy to the life of a child whose world has been turned upside down. And I cannot tell you how much I appreciate in the roles I've been in and the roles I am currently in, all of the hard work and the challenges you all have in front of you. I hope in this short time we've been together, I've been able to be of some assistance to you, but wish you all the best going forward. And again, thank you for everything you all do.
And thank you so much for your time today. Thank you, everyone, for attending our session. And if there is a noon session starting up with Gail and Blue Cross Blue Shield, so please make your way over there now. Thank you so much. I'll take good care. Thank you, Evan.
Thank you.